Hi, my name is Adam Whitmer and I'm your host here at ComplianceCohort.com. This compliance clip is going to discuss the application date for indirect applications when you are reporting under the Home Mortgage Disclosure Act. So this clip applies to HMDA reporters. Now, under the Home Mortgage Disclosure Act, we have a very simple rule for application date. The rule is just very simple. It says to list the date the application was received or the date shown on the application form. Now, sometimes we get questions that relate to the application date but aren't answered in the rule, such as the question being, what if we have an application that was not directly submitted to our financial institution? So, for example, you may have an application that comes in through a broker that's a channel other than directly to your financial institution. What application date do you use? Well, fortunately for us, the answer is found in the commentary of 1003.4A12, which is where the definition or where the requirements for the application date are found in Regulation C. And the answer is in comment 2 to that section of Regulation C. So comment 2 talks about indirect applications, and specifically it gives us 3 different reporting options. Now, the first option is that you can report the date the application was received by the party that initially received the application. So if you're working with a broker, you can list the date that it was received by the broker. The key, of course, in this is to have the broker to clearly document when they received it, whether they write on the top of the application form when it was received or writing the date in by their name at the bottom of the standard IRLA to recognize when it was received. That's your first option. Now, your second option is you can use the date the application was received by your financial institution. This may be easier for most of you because what you could do is keep a copy of the email in file that came from the broker, hopefully through a secured email, or if they send it the old-fashioned way, fax, right? That's the best I can do. Trying to keep these videos fun. But if it was received by fax, you could keep a copy of the fax, or maybe it's right on there and you could circle that, or you could have a stamp that says it was received this day, but you should be consistent and develop a procedure in order to document the date your institution received it if you're going to go that route. So that's the second option. The first option, again, is the date received by the broker. The second option is the date received by your financial institution. Now, the third option would be the date shown on the application form. So this could be the date the applicant signed it. It could be the date of the broker. It could be another date stamped. So there's so many different options here. You just have to pick one and be consistent. That is the key, is to generally be consistent in how you approach this, just like how you approach the application date when you receive an application directly through your financial institution. So they do give an example in the commentary. They say to generally use the same approach for certain categories of loans or for certain divisions within the organization. So for secondary market loans, you do it all the same way. For in-house loans, you do it all the same way, and so forth. So that is our topic for today. I hope you enjoyed this short compliance clip. Again, my name is Adam Whitmer, and I am your host and founder of ComplianceCohort.com. We have a lot of other videos just like this, a lot of articles, so take some time to explore, and I hope you have a great day.